This is the first in a series of short videos that will provide information about the Family Homes on Reserves and Matrimonial Interests or Rights Act, or the Act, to keep things simple. We will look at why Canada enacted this Act, which was passed on June 19, 2013.
Since 1867, the Indian Act has governed reserve land, homes and buildings on reserve land, and property interests of residents living on reserve. The Indian Act did not include any provisions for addressing the division of matrimonial property or any related rights of spouses or partners in the event of a divorce or the breakdown of a common law relationship. The Constitution Act of 1867, under Section 9124, provided the federal parliament with jurisdiction over Indians and lands reserved for the Indians. Under Section 9213, it provided the provincial legislatures with jurisdiction over property and civil rights in the province, including matters related to family law. The Supreme Court of Canada had ruled on a case in 1986, determining that provincial family laws could not be applied where the Indian Act had jurisdiction. Essentially, no legal venue existed where the division of matrimonial real property or protection of any related rights could be addressed by partners dissolving their relationship. The result was a legislative gap. The Family Homes on Reserves and Matrimonial Interests or Rights Act was intended to balance the collective interests of the First Nation and the individual rights of spouses and common law partners living on reserve. The Act came into effect in two stages. Starting on December 16, 2013, First Nations have the authority to develop and implement their own matrimonial real property or MRP laws. The Centre of Excellence for Matrimonial Real Property developed and continues to provide training to First Nations to assist in MRP lawmaking and ratification. Exactly 1 year later, on December 16, 2014, provisional federal rules contained in Sections 12 to 52 of the Act took effect. These interim rules provide rights to spouses and common law partners during a relationship and after it ends, either through divorce, separation, or death, with respect to the use, possession, and occupation of family homes on reserves, and the division of value of any interests that they hold in structures and lands on the reserve. If your First Nation has enacted its own MRP law, has a self-government agreement, or is a signatory to the Framework Agreement on First Nations Land Management, these provisional rules may not apply. It's important for individuals to determine if the legislation applies in their specific circumstances. Once a First Nation enacts its own MRP laws, the provisional federal rules no longer apply.
To access the MRP Toolkit and for further information, please visit our website at COEMRP.ca. This video is for information only and should not be relied upon as legal advice. Individuals should always obtain legal advice from a lawyer familiar with their specific circumstances and the provisions of this Act.